Hello, my name is Albert Varilone and I'm a solicitor. I've been asked to present this video clip on behalf of Landlord Risk Management in order to highlight to landlords and letting agents their legal requirements and obligations under the Legionella legislation in the United Kingdom. This is aimed at minimising the risk of exposure to the Legionella bacteria in residential lettings, which became subject to the legislation in 2013 when the 300 litres rule, i.e. 300 litre water system capacity, was removed. The seriousness of the diseases caused by the Legionella bacteria is marked by a 10 to 15% fatality rate regarding Legionnaire's disease from diagnosis of infection and up to 80% in the elderly. The disease caused is very similar to and often mistaken for pneumonia. The presence of any cold water system on your client landlord premises, i.e. all residential premises, as such let premises must have by law hot and cold running water, or indeed anything to do with the supply of water, should alert you to the need to familiarise yourself with these legal requirements. Landlords and letting agents are both in control of premises and therefore responsible persons within the meaning of the legislation. There are several pieces of legislation covering the workplace, hotels and restaurants, and now residential lettings. But the HSE ACOP L8, i.e. Approved Code of Practice, last updated in 2013, sets out guidelines which, if followed and with the procedures documented, should prove to the relevant authorities that you take compliance seriously. The Code of Practice gives advice on achieving compliance and gives general information as well. The HSE's position is ambiguous in that although they point out quite rightly that a certificate is not required by law showing Legionella-free premises, an assessment and plan to remove and review is required, as I referred to below. Although the Code of Practice is not itself legislation, i.e. an Act of Parliament, if you are prosecuted for breach of health and safety law, and it is proved that you did not follow the relevant provisions of the Code, you will need to show that you have complied with the law in some other way, or a criminal court is likely to find you at fault. In addition, the steps recommended, if adhered to, will go a long way to help you fight your corner should civil proceedings ever be issued against you or your landlord clients. Anecdotally, approximately £200 million has been identified as being claimed in civil proceedings involving Legionella, and insurers will inevitably be taking a view on precautions and fulfilment of obligations taken by responsible persons. You may, of course, if you ignore the guidelines, be prosecuted in the criminal courts and face civil proceedings for damages. In the case of fatalities, say, of tenants, it is conceivable that manslaughter charges could be considered, and the fact that you operate behind a limited company may not be sufficient protection. This is not new law. In 2006, a council architect was charged with manslaughter through causing a Legionella death, but was on the facts then acquitted. These guidelines are intended to help in identifying risk and assessing it by appointing a person in your organisation to be responsible for others in the organising or using of its facilities, and producing a scheme to control those risks assessed. Once implemented, these precautions should be regularly reviewed. I urge you to look at certain conditions set out in the Code of Practice which may increase the risk of Legionella, and why it is important to control the risks and introduce measures to prevent proliferation of the organisms in your water supply which may carry the disease. Indeed, if any assessment of possible contamination does not include the taking of a water sample for testing by a UCAS accredited laboratory, it is likely to be a flawed assessment. Landlords and letting agents are identified as duty holders in the information accompanying in the guidelines, and since 2013 these include, as I've said above, residential premises also. In respect of the duties as set out above, when carrying out a risk assessment, the guidelines urge you to take into account the individual nature of the site and consider the site as a whole. Keep thorough and appropriate records of risk assessment. Devise a course of action to prevent and control any identified risks. Under general health and safety law, as a landlord or letting agent in control of premises, you have health and safety duties and need to take suitable precautions to prevent or control the risk or exposure to Legionella. The guidance is in 3 parts. Part 1, the control of Legionella bacteria in evaporative cooling systems. Part 2, the control of Legionella bacteria in hot and cold water systems. Part 3, the control of Legionella in other risk systems. It is likely that Part 2 is by far the more likely to impact on landlords and letting agents, and the assessment should include special reference to water supplies when the temperature is between 20 and 40 degrees, or where there is stagnant water, or where there is rust or sludge, or where water outlets are rarely used, or where there are vulnerable tenants, for example the elderly or the ill. The assessment should also be regularly reviewed. Any assessment and any findings and steps taken to address contamination should be kept by you for a minimum of 5 years. Finally, I thank Landlord Risk Management for enabling me to make this presentation, and by way of a conclusion make the observation that if you are a landlord or letting agent, and if you choose to forego the modest costs involved in obtaining an independent assessment and treatment plan in respect of premises let or managed by you, then you are possibly treating the new legislation and code of practice with significantly less seriousness than either warrants.